Good morning, Nigeria. Welcome to Let's Talk Nigeria on Golding 97.5 FM Yanagwa, your go-to platform for insightful discussions on law, governance, and issues shaping our society. A recent courtroom incident has sparked serious debate about the powers of a trial judge and the boundaries of judicial authority. The issue arises from a case involving Mohammed Umar and Marshal Abubakar. Well, according to reports, during court proceedings, in response to counsel raising his voice, Honorable Justice Mohammed Umar directed the lawyer, Mr. Marshal Abubakar, to step out of the bar and kneel down. Now, the situation reportedly escalated further with threats of committal for contempt of court. Now, this development has generated widespread concern within legal circles and beyond. In fact, the NBA president, Afam Osigwe, also released a press statement. And it raises a critical and thought-provoking question. Is this an appropriate exercise of judicial power, or does it amount to a violation of the dignity and professional standing of a legal practitioner? Well, there is no doubt that trial judges are empowered to maintain order and decorum in the courtroom. The authority to caution, discipline, and even cite individuals for contempt is an essential part of ensuring that proceedings are conducted with respect and seriousness. However, these powers are expected to be exercised within the framework of the law, guided by principles of fairness, proportionality, and respect for the legal officer of the court to kneel raises fundamental concerns about professional dignity, human rights, and the relationship between the bench and the bar. It also prompts deeper reflection. Where should the line be drawn between enforcing courtroom discipline and preserving the integrity of the legal profession? At a time when public confidence in institutions is crucial, incidents like this have the potential to shape perceptions about the justice system. They call for careful examination, not just for what happened, but of what the law permits and what ethical standards demand. Well, to help us explore these issues, we are joined this morning by a legal mind all the way from Port Harcourt, who will be speaking with us on this issue. Now, he will provide legal insight into the scope of judicial powers, the concept of contempt, and whether this incident aligns with established judicial conduct. He is no other but Mr. Obon Ezekiel Esquire. Thank you so much for joining us on the show this morning.
Thank you, Doc, for having me. Good morning, listeners.
That's right. So, listeners and all over the world, we are live on Facebook right now, 97.5 Golding FM. You can join us. We're streaming live right there, and you watch the program. Stay with us as we unpack this important topic. This is Let's Talk Nigeria. Yes, we told you that in a statement issued on Tuesday, the NBA president, Afam Osigwe, said the association viewed the development with utmost seriousness, citing its implications for the dignity of their legal profession and the sanctity of the courtroom. And I quote him, he said, "The courtroom is a temple of justice governed by law, procedure, and decorum. While judges are vested with authority to maintain order and discipline in the courts, such authority must be exercised strictly within the bounds of the law and established judicial standards." So that's what he said. Well, it was a very long text, actually, a long press statement. To begin with, Mr. Ezekiel, what are the legally recognized powers of a trial judge in maintaining courtroom discipline? Let's start from there.
Okay, thank you very much, Doc. Judicial powers are the powers decided by judges in Nigeria, and these are provided for basically in the Constitution of the Federal Republic of Nigeria, 1999, as amended. Those powers are provided for in Section 6 of the Constitution. So it talks about the inherent powers of the court to protect its own integrity. The court also has the powers to control its own proceedings. It has powers to interpret cases that are brought before it by either individuals or between individuals and corporate organizations. The courts also intervene when there is a conflict between the other arms of government, for example, the legislature and the executive, over a course of action or a policy of government. It is the function of the judiciary to wade in and interpret and make judicial pronouncement as to what the position of the law is. As a matter of fact, the powers of a judge are very extensive. They are quite extensive. Very, very extensive.
So based on the incident involving Honorable Justice Mohammed Omar and Marshal Abubakar Esquire, does directing the lawyer to kneel fall within those powers?
Well, as a matter of fact, in legal parlance, there are situations envisaged by the law where a judge can invoke its powers to punish contempt. And that can apply in two situations. The first situation is what we call contempt in facie curia. That is a situation where a conduct appears to be offensive to the integrity of the judge, and such conduct having taken place before the judge in the courtroom. So two things are involved. There's a misconduct or an apparent misconduct. That misconduct actually takes place before the court. That's contempt in facie curia. Then we also have another form of contempt, which is contempt ex facie curia, which is the form of contempt that takes place outside the courtroom. For example, when somebody makes a libelous or an offensive publication, we'll be talking about a judicial proceeding or name calling a judge and all of that, that such publication is capable of dragging the reputation of the judge in the eye of the public into the mud. So that, for example, can stand as a situation where the court can invoke its powers to make declaration of contempt ex facie curia. So those are two. So in this circumstance, the instant case, it can very well fall into the category of contempt in facie curia, that is contempt before the court. But the issue now is, how do you define contempt? There's no explicit provision on what constitutes contempt. It's subject to the interpretation of the court. All right. So in this circumstance, if the conduct of a lawyer, of course, in the first place, the relationship between a lawyer and a judge is supposed to be mutual respect. It's supposed to be, the profession of law is such that it provides for mutual respect between the bench, that is the judges, and the bar, that is the advocates. So every advocate, by training and by the ethics of the profession, is expected to exercise restraint in the courtroom. Is expected to show decorum, maximum decorum in the courtroom. So in that circumstance, I understand that in the second one before Justice, the one before the Federal High Court, Justice Mohammed Omar, I understand that there was an altercation sort of over the issue of a hearing date, the suitability of a hearing date. So I wouldn't know the extent of the interaction between the two levels, the bench and the bar at that point. But what I understand by the ethics of the profession is that the judge has the power to actually commit an offending lawyer for contempt of court. That's the practice. But the circumstances will have to be clear and visible to all present. It has to be an apparent circumstance. It's not something that is not a subjective application. So I think the question people have been asking is whether asking a lawyer to kneel before the court is actually within the powers of the judge. As a matter of fact, it's the first time I've had any such.
Okay, great. So, but what if the lawyer had refused to kneel? What would have happened to the lawyer? Does he have? I mean, what? Let's just imagine that when he was asked to kneel, he refused to obey. What would have been the next action? And secondly, what recourse is available
Yeah.
to that lawyer who feels humiliated or unfairly treated by a judge in open court? What recourse is available for him? Made a statement. What role should the Nigerian Bar Association play in this situation, apart from giving press statements?
Yes, even from the statement itself, the NBA president, Alpha Musigwele, Senate of Nigeria, has already given an indication, of what will happen. Definitely, there will be an investigation. An investigation will be commenced, I believe, into what actually transpired in court. The NBA cannot, even though the NBA had made a statement to arrest the situation, to urge calm from all actors. That's the right thing to do. So, but I believe the NBA will take a step further to review the situation through its investigation and actually determine whether the activities of the lawyer at that court in that instance amounted to professional misconduct, or whether it's, as a matter of fact, who was at fault in that circumstance. And the NBA can also take a further step, having arrived at the position as to whether who was at fault. The NBA can take a further step to take a decisive step. If it is the lawyer that was at fault, the lawyer could be presented for disciplinary action. And if it is the judge, as a matter of, and if the judge's action that's not to say that the judge's action cannot be disciplined. The judges have their own disciplinary procedures as well. The National Judicial Council actually is the body with the power to discipline judges. So, and the judges have what we call code of conduct for judicial officers. So, if there's a complaint, for example, the NBA, if a case is made out on the face of it that the pronouncement of the judge, the action of the judge was above bar, the NBA also can decide to come up with a petition against the judge before the NJC, the National Judicial Council, to investigate and also carry out necessary disciplinary actions against the erring judge.
The NBA president said it seems that practice is quite new because, like you said, you've never heard anybody ask anyone to kneel down or any judge asking anyone to kneel before. So it's not even part of the judicial system or the law. So why do you think the NJC has not said anything?
Like I said, the NJC will not just come. I know the legal profession is bifurcated. You have the bench and the bar. Now the bench is always reserved. As a matter of fact, as part of the code of conduct for judicial officers, you're not supposed to defend yourself. You're not supposed to defend yourself in public. You're not supposed to make public statements and so many other restrictions. So it is actually the bar that most times advocates on behalf of the bench. The bar, that's the Nigerian, when I said the bar, I'm talking about the advocates, the barristers, those who represent clients in court and all that. They are the ones that actually advocate on behalf of the judge, because the judges are, by their profession and by their ethics, are not supposed to be seen in the public, interacting excessively, making statements, religious statements and all that. So I believe that the NJC, of course, would have taken notice of the situation, would have taken notice of it, but it is not expected that the NJC will come forward to start making statements in public. Perhaps what they will do is to do the would also have started that process. But like I said, in this instance, I think the NBA has done the right thing by making a statement to urge all parties to remain calm. And then we'll swing into action in carrying out the investigation. At the end, conclusion of that investigation, which I hope will not take quite a long time, the NJC will come up with a decision on what next line of action to take. So if the Nigerian Bar Association sees that the action of the judge in question is above board, a little bit overboard, I think the NBA needs to, by drawing the attention of the National Judicial Council to the
Stay on the
situation.
line. Don't go anywhere. We want to open the phone lines quite early this time because it's an interesting conversation. A lot of people might just want to be part of it. So we'll open the phone lines quite early on the show. And if you are interested in this conversation and you want to chipping a word, well, it's now your time. 0707 747 1522 and 0912 0001975 are the numbers. You can also go on Facebook. We're there live. You can drop your comments there. We could read them out. And also, you can send a message on WhatsApp to the number 0912 0001975. I've got this question on WhatsApp. Great. So you're actually following us really, really hard. This one is from a king from Ezekiel said, "Good morning, Golding FM. Is it possible for the NBA chairman to discipline an airy judge?" I guess that answer had already been given, that it's left for the NJC to do and not NBA president to do that. But I don't know, Obong, you had something different from what, I don't know, someone is just want to find out whether the NBA president had the power to do that. But do you have any contrary response to that?
No, the NBA cannot discipline a judge.
Okay, great.
They don't have, it's not within the.
Okay.
Not within the.
All right, you've answered the question there. Let's take the calls now. Hello, good morning.
Hello, good morning.
Good morning.
Hi, I'm Barton.com. From Kroger. I want to know if, like that barrister now, and the son have the right to sue. We have everything. The conduct of the judge is wrong. And that barrister on his own has the right to sue that judge. Therefore, I put it. Is it a difference of character or that is a public assault? Thank you.
Okay, well, he's going to answer that question. Obon, you please listen to all the questions. Hello, good morning.
Yeah, good morning, Moyo Stephen Akolbasa.
Good morning.
This is Jackson. I'm calling from Mirengi Road. Yes, quick question to your guest. My question is, when is the word or the verdict of a judge binding? Is it when he is at the court or the courtroom where he's sitting on his desk? That is when his word is binding, or him as a human being after the courtroom, maybe if he sees a crime being committed in his presence with enough evidence, can he pass a verdict at the spot? Maybe he's with a security person and say, get this man arrested, and I'm speaking as a judge, that there's this word, the binding. Is it applicable when he's outside, or is only when he's in the courtroom? Then second question is, when this matter of content is raised, let's assume that it is the accused, maybe someone is defending the accused that is going overboard. What can happen to that person? Aside is the accused.
But let's get back to our guest in Port Harcourt. Umong Ezekiel Esquire, would you want to respond to some of the questions before we return to the calls?
That's okay.
Yes, go ahead.
All right, then. All right. I think the first question touches on the concept of judicial immunity. A judge has a certain form of immunity in what happens in his courtroom. All right. So asking whether a lawyer can sue the judge as a result of the situation in the courtroom is not likely to happen, because it's an exemption. All right, it's an exemption to the rule of defamation. The judges have immunity in the courtroom. So, but like I said, the judges also have to exercise restraint in their own conduct in interpreting what situation amounts to contempt. So there has to be a balance between both sides. Now, on the issue of whether a pronouncement made by a judge in itself is complete, whether in the court or outside the court. Yes, there's what we call summary trial. Ordinarily, a trial takes place when a full trial takes place where the lawyer should advocate. It means that the courtroom might be turned into a rowdy place where anybody can step in and start talking and shouting, screaming. So that is why, as part of the training of lawyers, even right at the law school, the lawyers are trained. There's a course called professional ethics for lawyers. So the professional ethics of the lawyer would not permit a lawyer to raise his voice unduly while speaking to a judge for whatever reason. You should not. The lawyer is a master of his emotions. In that instance, he is expected to be a master of his emotions. So he's not supposed to unnecessarily extend his voice such that to amount to talking down on the judge. So that's the situation.
Okay, great. Master of his Okay, so great. So when you say you're the master of emotions, I like the fact, but then sometimes it seems as though the lawyers will not be human at some point, because at some point you want to be human, right? But let's take a call. Hello, good morning.
Yeah, good morning. My name is David West.
Okay, good morning.
Good morning, yes.
My humble opinion with respect to this issue. I think it is not proper for my Lord the Judge to demand or order a counter who appears before him to come to the open court and kneel down. He's more so he's fully robed with the wig and gown. Are we not demeaning the legal profession? Agreed. The judge is a master of his court. But however, the thought of ordering the learned counsel to come to the open court before his clients, is really, really disturbing to me. So I'm saying I think the NJC should look at it, and also the Nigerian Bar Association should look at it.